In fact, as Governor Brown made her remarks relative to a tragedy that has recently occurred in the Multnomah County and specifically the city of Gresham, it was my, once again, duty to respond to that scene of that tragic event where a man had murdered his two daughters and then turned the firearm upon himself. And I must tell you, the images of those events, the response and the scene of certain things will leave an indelible mark on any person at any time. And that event does with me as well. So my desire, while it began years ago, and relative to this bill, Senate Bill 868, more recently, months ago, it is renewed with vigor and a pressing sense of urgency that we continue to work with family members in our community, offer them services, but also simultaneously allow for law enforcement and family members who are aware that a family member of their own is in crisis, that we allow for a legal vehicle, to dispossess an individual of a deadly weapon. Senate Bill 868 does just that. As remarked on by Senator Boquist, the framework for which 868 is built upon a long-established constitutional methodology found in our Oregon's Family Abuse Prevention Act relative to restraining order issuance, ORS 107700, where we allow for an ex parte application to a court. So make no confusion about this. No one under this bill will be dispossessed of a deadly weapon absent a judicial order. There will be a judicial order issued following a family member or law enforcement based on information that they have available, either provided in affidavit form or in oral statement form to that judicial officer. That judicial officer at that stage will review evidence from a preponderance standpoint. That's that emergency, urgency sense that we need to, in this moment, because of this crisis of this individual, dispossess them of that deadly weapon. Upon that issuance, law enforcement, by and large, will be the ones to serve that order upon the respondent, to carefully, safely, and hopefully appropriately for sure, and hopefully crisis avoidance effort to dispossess that person in crisis of their deadly weapon. Built within this statute, as is in the Family Abuse Prevention Act restraining order, is a due process right. Because that individual who's been dispossessed might very well feel that they've been wrongly dispossessed. We have built in this statute that ability to have that hearing, once again, in front of a judicial officer. A right of, if you will, confrontation. The Oregon rules of evidence will apply at that hearing, and that hearing's burden of proof is clear and convincing for that court to continue that order, if appropriate, or, if inappropriate, to discontinue that order. Once continued, that order will remain in effect from a year upon its issuance, unless or until it is terminated by another opportunity, and Senator Boquist commented on that. The respondent or the petitioner, during that period of a year, even if continued at that initial hearing, may once again revisit that question if the circumstances in their minds have changed. The court would be given another opportunity to make a determination whether that dispossession should remain, or whether an alternative should occur and termination is more appropriate. This bill, as another piece that the Senator pointed out, is this bill provides no greater authority for law enforcement to search or seize than already exists in Oregon jurisprudence. We've attempted to make clear that point, essentially on page 14 of the bill, in the -1, that law enforcement has the authority, if appropriate and if necessary, to seek consent, or if they need to seek judicial authorization to conduct a lawful search of the premise in order to seize any firearm or ammunition or other deadly weapon pursuant to the order. I also want to take at least just a moment to comment on my support for Senate Bill 797, the expansion, if you will, to close that what's been termed the boyfriend loophole But at times when we use those phrases, I tend to think in my mind that's somewhat casual. What we're really talking about is relationships that have gone terribly tragic oftentimes. Profession, I have responded to those crime scenes as well, to incidents where a domestic partner or former, whether it be a husband and wife, or we're closing a loophole relative to an abusive boyfriend oftentimes, abusive partner. It is appropriate for us to expand into that area, to dispossess that individual, again, under the circumstances that I've outlined. And then further, the other provision to continue an order by operation of law, and not that if the court has issued an order and it has not otherwise been terminated, that order is in place and continues by operation of law the dispossession of that firearm. And then the closing of the loophole, the other loophole as well. But I want to circle back around to and finish up our remarks. I think we're probably time restrained. Senate Bill 868, it is the right time, it is the right place. The Gresham scenario, I don't know if this piece of legislation would have changed that trajectory, where those two young girls, 8 and 11, and that man who's obviously in crisis were to be alive today. But I am here to say that while we may not be able to change the trajectory of every circumstance, in the business I'm in, I have never been able to place a price tag or an effort or legislation on a human life. I think that it's only going to take one. I don't know which one it'll be that we save their lives, whether it be a homicidal or suicidal ideation. But it's the time and place for Oregon to step forward and do this and move this bill forward. Thank you very much.
Thank you very much. Questions for the panel? Thank you very much for coming forward. Our second panel will be, invited panel will be Representative Williamson, Sheriff Reese, and Janine Yulee. I think I said the first name wrong. Jenna, excuse me, is written down below.
Good morning, Chair Przonski, members of the committee. For the record, my name is Jennifer Williamson. I'm the state representative for House District 36, Northwest and Southwest Portland. I want to first start by thanking you for holding this hearing and to thank everyone who signed up to testify today or submitting testimony and taking part in this conversation. Too often we see horrific carnage caused by mass shootings, attacks in our schools and in our communities. And although they go less reported in the news, we know of countless women and children who've been hurt or killed by an abusive partner with a firearm. We've taken steps over the past few years towards ensuring that dangerous individuals, violent criminals, domestic abusers don't have easy access to firearms. I want to thank the governor for her leadership on gun safety, and I want to thank Senator Burdick and Boquist for all their hard work on Senate Bill 868. We know that families and law enforcement currently lack the tools to help at-risk firearms owners. This legislation would protect Oregonians from hurting themselves and others during a time of crisis, and I look forward to supporting this bill when it comes to the House. On paper in Oregon, we require that all potential buyers of firearms pass a criminal background check before they can purchase. Except in practice, we have a large loophole that allows folks to purchase a firearm without a background check if that check takes longer than 3 days. It doesn't matter ultimately after 3 days what comes back in that buyer's background. I want to share just a few numbers from the Oregon State Police to help put this bill in perspective. OSP conducts more than 250,000 background checks for gun sales per year. Some 94 to 96% of those checks are completed within 5 minutes. Now, I know that you've heard that it takes longer than that. If there are lots of people in the queue, it may take longer, but the actual check takes less than 5 minutes. The other 3 to 6% go into something called the pending status, meaning they've been flagged for further review to determine if a buyer is eligible. An example of this kind of flag is if someone has a restraining order in another state, and the background check officer at OSP must physically go pull the file or call that state to find out whether or not that restraining order is one where that person cannot own a firearm in Oregon. But if this process takes longer than 3 business days, the seller has the discretion to sell the gun anyway. A further look at these numbers are alarming. The denial rate for background checks is 0.073%, so less than 1%. But the denial rate for those who go into the pending status is 5%. In other words, a background check that goes into pending is 5 times more likely to ultimately show that the buyer has something in his or her background that disqualifies them from owning a firearm. The top 3 most common reasons for denial last year were a purchaser having a felony record, being on probation, or in fugitive status. Now, I know that most responsible gun dealers will wait until the background check is fully completed before selling their guns, but not everyone does. We've heard that we need to do more to go after bad guys who try to buy guns when they shouldn't, and this bill gives local law enforcement a better ability to do just that. Senate Bill 797 would also protect vulnerable women by doing 2 things: closing what's called the stalker loophole by prohibiting the sale of a gun to anyone convicted of stalking, and by closing the boyfriend loophole, which updates the definition of relationship status pertaining to certain kinds of court orders. I believe we owe it to our communities to pass common sense gun laws that keep them safe, and closing these loopholes are the right thing to do, and we'll do just that. Thank you.
Thank you. Who's going to go next?
Good morning, Mr. Chair and members of the committee. It is my pleasure to be here with you today to testify in support of 2 key pieces of legislation. For the record, I am Multnomah County Sheriff Mike Reese. As a law enforcement executive with more than 25 years of experience, including 4 years as the Chief of Police for the City of Portland, and now as an elected sheriff, I've seen firsthand the incredible damage communities suffer as a result of irresponsible firearm use. As a result, I'm here today in support of Senate Bill 797 relating to the responsible gun ownership, because it aims to reduce gun violence in the communities law enforcement serve. I'm also here today in support of Senate Bill 868 relating to extreme risk protection orders, because it aims to reduce self-harm among the vulnerable individuals law enforcement strives to protect every day. The proliferation of guns in the hands of dangerous people is the #1 threat that law enforcement professionals face daily. Over the last 2 years, approximately 1,700 firearms-related crimes were reported within Multnomah County alone. In domestic violence cases, all too often the victim is a woman terrorized by her partner. Currently, Oregon law rightly prohibits certain domestic abusers from buying or possessing a gun, but more needs to be done to strengthen the current rules. Senate Bill 797 would bring about several important changes to Oregon's gun violence prevention laws, including closing the boyfriend loophole, adding abusive dating partners and convicted stalkers to the list of those prohibited from purchasing or possessing a gun is an important measure that will protect women and children. Simply put, keeping guns out of the hands of abusers is the best way to prevent them from shooting and killing their victims. Senate Bill 797 will also help strengthen our ability to enforce current law. When someone who isn't legally allowed to have a gun tries to buy one and fails a background check because they are a felon, domestic abuser, or have a dangerous mental illness, that's a red flag. And it is also a crime. If you lie when you try to buy a gun, you've broken the law. A coordinated and timely response that alerts local law enforcement when a prohibited person tries and fails to buy a gun is an important way to help us keep the next crime from happening. As a gun owner myself, I support the rights of responsible owners. However, there must be a balance between protecting our rights and taking every step necessary to protect our communities from gun violence. Senate Bill 797 strikes the balance and represents a reasonable and necessary step forward. Senate Bill 868 addresses a gap currently in Oregon law. By recognizing extreme risk protection orders, a court-issued civil order that empowers families and public safety to work together to prevent gun tragedies. Family members are often the first to know when a loved one is in crisis. It's difficult to witness a loved one regress and engage in dangerous behaviors, thus necessary for family to have a meaningful next step when they are concerned about the risk of self-harm or even the potential to hurt others. Though temporary prohibition on the purchase of new or dispossession of existing firearms, Senate Bill 868 gives families and law enforcement officers a valuable tool to intervene in complex and quickly evolving situations such as a mental health crisis. people experiencing a crisis may be at an elevated risk of suicide. We know that research shows that people are more likely to die by suicide if they have easy access to a firearm. In fact, 40% of all suicides within Multnomah County involve a firearm. Those in suicidal crisis are much more likely to survive if they don't have easy access to firearms for the duration of the crisis. Law enforcement knows all too well that mental health crisis, which could result in harm to self or others, benefit from time and compassion. Senate Bill 868 creates a moment for clarity and an opportunity to match an individual's need to available services. Closing these collective gaps in the law go a long way toward reducing the incredible damage irresponsible use of guns does to our communities and to vulnerable individuals in need of our assistance, while still preserving due process and other constitutional rights. Thank you for the opportunity to testify this morning and for your support of these critical measures. Thank you.
Thank you.
Good morning, everyone. I would like to thank Chairman Brzezinski and members of the Senate Judiciary Committee for allowing me to testify today in support of Senate Bill 868, the Extreme Risk Protection Order. For the record, my name is Jenna Ewell, and I am the Regional Manager at Americans for Responsible Solutions, which is the gun violence prevention organization started by former Congressman Gabby Giffords. I grew up here in Oregon. Some of you might remember the story of my mom, Cindy Ewell, who was shot and killed at the Clackamas Town Center shooting on December 11th, 2012. I was 23 years old, and losing my mom was more difficult than I ever could have imagined. 4 years later, I never could have guessed that I would be losing my dad too. His name was Michael Pasalakwa. I just turned 28 in February, and I have now lost not one, but both of my parents to gun violence. I knew that my dad wasn't doing too well, but I didn't know how to help him. On July 18th, 2016, he went to a gun shop, and he bought a gun. I know that because of the receipt that I later found in the same box that the gun came in that was still under his bed. If I'd known that a tool like the Extreme Risk Protective Order was available, I would have used it, and my dad probably wouldn't have been able to go buy a gun that day. An Extreme Risk Protection Order enables families to work with law enforcement to temporarily remove guns and prevent the purchase of new guns by an individual who poses a risk of hurting themselves or others. After my mom was murdered, I kept asking myself, how could this have happened? What could have been done to prevent this? And what could be changed to make sure that the same exact situation doesn't keep happening again and again to other families? Research shows that people experiencing a crisis are much more likely to die by suicide if they have easy access to guns. Nationwide, 60% of all gun deaths are from suicide, and 85% of suicide attempts that involve firearms are fatal. My dad was one of those 85%. His suicide attempt with a gun was fatal. Passing this bill would give families and loved ones an opportunity to reduce the risk of suicide for someone in crisis and provide safer circumstances for them to address the underlying causes of these dangerous behaviors. My dad was a brilliant man who had a hard time being happy in this world, but an ERPO could have saved him. Let's give other families an effective way to do something for their loved ones who they know are struggling. I would like to thank Senator Burdick and Senator Boquist for their leadership in introducing this important bipartisan bill. I know that it will save lives, and I urge the committee to pass this critical piece of legislation. Thank you.
Thank you. Questions? Thank you very much for coming. Invited panel will be Keely Hopkins and Kevin Starrick. Good morning.
Good morning.
Good morning.
Chair Przansky, members of the committee, my name is Keely Hopkins. I'm the state liaison for the National Rifle Association, here today in opposition to Senate Bill 764, 797, and 868. Starting off with Senate Bill 764, while there are some good portions of this bill, the NRA is opposed because of the changes it makes to the competency requirements in order to obtain a CHL in Oregon. Current law allows for the requirement to be met through a variety of means, including through training offered by an online course. This keeps costs low for Oregonians and also accommodates individuals in all parts of the state. The NRA strongly supports firearm safety, education, and training. However, we don't believe that it's our role or the role of the legislature to determine who may enjoy a constitutional right based on how much or what type of training they've received. Every person's situation is different, and citizens are capable of gauging what their needs are and deciding on their method of training. If you're a gun owner, you should own safely and responsibly and practice as often as you can, and gun owners do. The additional requirements under Senate Bill 764 will make it difficult for Oregonians across the state to obtain a CHL and have a firearm with them for self-defense. We have concerns that these requirements will increase the cost of courses, and also concerns about the availability of these courses given the associated range time requirement. We urge you to oppose this bill and maintain the current CHL requirements for Oregon. Senate Bill 797 and the concept of indefinitely delaying firearm purchases has been before the legislature before, and the NRA remains opposed. Firearm ownership and self-defense is an important right, and Oregonians rely on the state to conduct and complete background checks in a timely manner. An indefinite delay in a background check makes it impossible for a person to legally purchase a firearm. The 3-day time period was intentionally designed to provide a safeguard to protect the rights of law-abiding citizens. If there are inefficiencies in this process that are causing delays, then let's find solutions to those problems, not just give up on the state's ability to process these checks in a certain period of time. Lastly, the NRA is also opposed to Senate Bill 868. We do want to thank Senator Boquist for reaching out to us on this bill and for listening and addressing some of our concerns. There have been some improvements to parts of Senate Bill 868 with the proposed amendments, but we still remain concerned about the lack of due process in this bill that takes place at the initial hearing. This bill allows for a protective order to remove your Second Amendment rights, not because of a criminal conviction or a mental health adjudication, but based on third-party allegations using an evidentiary standard that falls far below what's normally required for the removing of fundamental rights. We understand the intent of wanting to prevent people from harming themselves or others. However, if a person's truly dangerous, existing law already provides a variety of mechanisms to deal with this individual, all of which can lead to firearm prohibitions in appropriate cases. This protective order does nothing to deal with the underlying dangerousness, nor does it subject the person to any physical restraint, evaluation, or treatment. This order merely takes away a tool and then continues to leave that person a risk to harm themselves or others without any further intervention. So again, we urge you to oppose Senate Bill 764, 797, and 868. Thank you for your time.
Thank you. Kevin?
For the record, my name is Kevin Starrow, Senator Manning. Congratulations on your appointment. We oppose all three of these bills. Time does not permit me to elaborate on the many flaws in them, so very briefly. Senate Bill 764 creates conditions to acquire a concealed handgun license that are onerous, unnecessary, and for most people, impossible to comply with. But that was the point, wasn't it? Senate Bill 797 eliminates the right of qualified people to purchase firearms as long as the Oregon State Police cannot or will not do their job. I recently had a student in a gun class who praised the response of the state police after she was denied a firearm because it only took her 8 months to get it straightened out. She thought that was very successful. 95% of the delays, as Representative Williamson just told you, are in error. 95%. This is the kind of failed system that we don't think should be rewarded. As for Senate Bill 868, we think this is kind of a fantasy. The bill allows a person who has not been convicted of a crime to have his rights and possessions stolen at the whim of a politically motivated, unaccountable, and usually unelected bureaucrat. You may recall that Judge Kenneth Walker proclaimed in open court in Multnomah County that no one, not even the police, should be allowed to have guns, and that if he had his way, they would all be put on a barge and dumped in the ocean. So what chance does anyone having their rights taken away have in his court? Furthermore, while purporting to address people who are violent or suicidal, there is not one word in the bill or the amendments that actually addresses violent behavior or offers help for people who are self-destructive. We strongly urge a no vote on all three bills. Thank you.
All right, first, before we take questions, I'm going to give you both opportunities to speak longer if you have other things. Kevin, it sounded like you might have wanted to say more. I tried to get word to you. I don't know if Roger Bauer got word that we wanted to extend the time because it turned out there was a second panel that was invited for the second bill. So if you'd like to take a little bit more time, please do so.
Well, I would like to address the CHL requirements that are being changed. I have no idea how those requirements could be complied with under the current law, under the situations that we have now. Because frankly, NRA firearms instructors are firearms instructors. They're not trained in the law, they're not, and frankly, although I give classes in Oregon gun laws all the time, most NRA instructors don't do what I do, which is study Oregon gun laws. And Oregon's laws on deadly force, while written in black and white, are often dealt with very differently when you get into court. And so I believe that most firearms instructors would be very, very hesitant. I believe the NRA discourages their instructors from doing training that includes the law. As for requiring live fire, we have sat in hearings number of occasions where as firearms training instructors and advocates, we have asked for the opportunity to expand the opportunities to build ranges, and those have been opposed. So while we have shrinking facilities for people to actually train, you are now asking people to have increased requirements at a time when, frankly, in states like Washington, there are no training requirements. And we haven't seen any problems. We haven't seen any issues. There's nothing happening that CHL holders are doing that would indicate that any of this is necessary. And so what we really find is that people's behavior is more a matter of judgment than training. We see a lot of police officers who've had extensive training still make mistakes. So I'm very, very concerned about that because I think it would virtually eliminate the opportunity for someone to actually acquire a CHL.
Thank you. Questions? Thank you all very much for coming forward. That concludes the invited testimony that was requested from the supporters as well as the opponents. At this point, we're going to start our testimony of the public. As I mentioned at the beginning, everyone will be limited to 2 minutes, and it's on the record already. So with that, the first panel I'm going to call up Alina Peugeot, I guess, Pergine. P-R-E-G-E-A-N, it looks like. Marge Easley and Elizabeth Caswell. And the way we'll be doing this, we will take a proponent panel and then we'll take an opponent panel. Good morning.
Morning. Do I state my name?
So whoever would like to start, we just need your name first on the record.
All right.
And then you'll have basically 2 minutes. You'll have a queue over on that side.
Okay.
Thank you.
Hi, good morning. My name is Linnea Prejean. I'm here in support of Senate Bill S797. I live in Portland. I'm a daughter and volunteer with Mommies Demand Action. I grew up in Newtown, Connecticut, part of which you know as Sandy Hook. And I know from up close and personal the impact gun violence has on a community. I watched my town get shoved into the spotlight. And I had a really close friend from high school who lost his mom that day. My best friend's mom lost a lot of colleagues. It's still very difficult to talk about. And while specifically 797 would not have prevented Newtown, it will take a huge step towards ensuring that existing gun safety laws are followed. We can do better to help our communities and our neighbors and our children by requiring state and local officials to alert law enforcement when an individual prohibited by law from purchasing a firearm attempts to buy one illegally and fails a background check. Passing this bill will save lives, and it may prevent another community from being consumed by preventable tragedy. No one should ever have to go through that, and I speak from that personally. And thank you for your time.
All right, thank you. Who would like to?
For the record, my name is Elizabeth Caswell, and I live in Portland. I'm the mother of 2 children and a member of Mommies Demand Action. In 2013, I was honored as your Oregon Mother of the Year. And in fact, the last time I spoke at the Capitol, I opened your legislative session the week of Mother's Day, and I'm very happy to be back 4 years later. I'm here today in support of SB797 and 868. I am here on a school morning, a Monday morning. I woke up at 4:30 a.m. I packed a lunch for my daughter for school, and I drove down here in support of this legislation. In my time as Mother of the Year, a focus of my outreach was to domestic violence shelters and supporting the mothers and children there. What I experienced there changed me forever. In my written testimony that has been submitted, I cite statistics regarding the risks and dangers women face in the United States from gun violence. But these statistics do not communicate the fear and terror in the eyes of these mothers in domestic violence shelters who are afraid for their lives and for the lives of their children. These women are afraid that their intimate partner will kill their children in retaliation. We have seen this happen very recently. The mere act of a prohibited and dangerous abuser trying to purchase a firearm is a crime. Notifying the local law enforcement at this point in the process can save mothers' lives. You can help these women by voting yes on SB797 and 868. It will cover all intimate partners by closing the boyfriend loophole and notifying local law enforcement of the failed attempt to purchase. It will give mothers and their children the protection they deserve. Thank you.
Thank you.
Senator Prozansky, members of the committee. For the record, my name is Marge Easley. I'm here representing the League of Women Voters of Oregon, and specifically on Senate Bills 797 and 868. The League believes it is the responsibility of government to enact and enforce public safety legislation, which includes the bills that you see before you today. First, on Senate Bill 797, we believe that this provides logical steps to close loopholes to make Oregon's background check system and domestic violence protection system work more fairly, effectively, and efficiently. But I want to emphasize our support for Senate Bill 868. This bill, in our opinion, is a very important one in order to save lives by removing guns temporarily from individuals who clearly demonstrate they are a danger to themselves and others. We believe it will be an invaluable tool for victims of domestic violence, but even more importantly, for suicide prevention. Oregon's suicide rate is among the highest in the nation, is increasing yearly, and is more likely than not to involve a gun. Suicide is an impulsive act by an individual in crisis. Normally, if a gun is present, it is most likely the means and will most likely be fatal. We believe that 868 is a proactive step to reduce the risk of suicide by restricting access to lethal means. We do not believe it is an abridgment of Second Amendment rights because the right to own a gun is not unlimited and does not prohibit reasonable government regulations. It allows for limited time period and due process. Thank you.
All right, thank you. Questions? Ladies, thank you very much. Our next panel is going to be Jim Shaw, I believe, Philip Watson, and our morning. Who'd ever like to start off?
Okay. My name is Phil Watson. I'm here on behalf of the Firearms Policy Coalition, our members and supporters in the state. I believe the CHL issue was already addressed in adequate manner, so I'm going to address the other two bills. Currently, in the state of Oregon, like in many states, a judge can issue an order, protective order, and if he also wants to, he can also issue an order to take a gun from somebody as well. And I believe the other panelists admitted that in their testimony. So if they want to, the judge can issue an order. A law enforcement officer can show up to your door, and if you have a firearm, he can take that firearm from you. Furthermore, the bill, there was some tightrope walking there on Fifth Amendment issues, and they sort of addressed that, and that originally there wasn't enough protections built in. They added a little bit, but obviously it's still lacking, as well as the other bill, the loophole bill, supposedly. Currently, there's no effective, real way to appeal these delays in Oregon. A friend of mine just recently got delayed for more than 2 months. There's no effective way for him to appeal that. So right now, the current law in Oregon is really lacking on behalf of protecting the individual right to keep and bear arms. And I'd like to see that expanded, not limited. There are reasonable ways to commit people, to address people that are dangerous, and we're willing to talk to you about that. But further limiting people's right to keep and bear arms with no appeals process built in for those protections is very troublesome. Thank you.
Okay. Before we take more testimony, I just want to let the next panel know, so we have people in another room. Arlene, I didn't know you were in another room. So the next panel that will be speaking after this one is Allison Seymour, Charles McKenna, and Doreen Dodgen McGee, I believe. All right. So that will be our next panel, but please continue.
Hey, Irene Gilbert. I drove 12 hours to spend my 2 minutes in front of this committee, so I hope you read the testimony that I've submitted. Senator Prozansky and the rest of the committee, thank you for hearing from me. I'm speaking in opposition to all three bills. Senate Bill 764, I think that requiring an instructor to have 25 rounds of live ammunition when they may not have access to a gun range is unreasonable. Personally, I would not want to have 25 people with live ammunition in a classroom that I was teaching. I think it will discourage people from providing these very valuable classes, and so I'm concerned about that. I'm also concerned in that bill with 166.173, which says a city or county may adopt ordinance to restrict or prohibit possession of loaded firearms in public places. And if you look at the definition of public places, it is very much an attack on Second Amendment rights. As far as 797, we processed over 600 gun sales last year, and we had roughly 12 of those that were delayed. None of those delays ended up with being denied. So if there were a denial, I trust that the police would go and get those guns from the people. I need more time. 868, it gives me great concern because you're talking about people who have mental health issues, and there's nowhere in this that is requiring any kind of statement from a mental health professional, a psychologist, psychiatrist, anyone like that, to justify taking away people's guns. And the use of the term temporary is really not accurate in my mind, because when these people are accused of this, they can't have a gun for 5 years after the end of their period of restriction. I'm also concerned about how they're taking care of people's guns when they're in police custody, because usually they will not get them back in the same condition that they gave them. Thank you.
Thank you. Jim?
My name is retired law enforcement, NRA firearms instructor, police firearms instructor, and several other credentials that go with that. I have problems with all three bills. I'm opposed to all three bills. As a law enforcement officer, I was able to make a police officer's mental hold on people who appeared to be a danger to themselves or other people's. Not once in my entire law enforcement career were those people even held for the full 72 hours. They were released. In our own personal case, we had a case with my mother-in-law not too long ago. The judge's exact words, well, she may not know now what she did 5 minutes ago, but 5 minutes ago, she knew exactly what she was doing. I do not award your conservatorship. We now are facing $20-some thousand in IRS bills because the court said she was perfectly competent. But she wasn't, according to the IRS. We took her guns out of her house ourselves. She was not a danger to herself or anyone else. As far as the firearms instruction and 25 live rounds, we have a family farm, 300 acres, 75 acres of it's non-tillable. A year or two ago, this very body took away our right to put a firearms range there for training. These are bills that are aimed at preventing the ownership of firearms. And that's about all you can say for them. They need work. Mental health issues are a problem. Yamhill County had one of those problems. A person was taken in, a danger to herself. The mental health people released her from the hospital, told them to take her to jail. And she hung herself with a telephone cord. Until we get the mental health people on board, this bill is worthless.
Thank you very much. Any questions? All right, our next panel, as I mentioned, is Allison Doreen Dodden McGee, and I believe it was Charles McKenna. While they're coming up, our next panel that's going to be up after this one will be Bozev Beckwith, Ronnie Daniels, and John Woods. Who'd like to start?
Here's Prozansky, Vice Chair Thancher, and members of the committee. Thank you for the opportunity to provide testimony today. My name is Allison Seymour. I'm a registered nurse, and my professional practice is in medical telemetry here at Salem Health. I apologize, I'm still in my scrubs. I got off work at 7:30 this morning. I'm here today on behalf of the Oregon Nurses Association, representing over 14,000 nurses in our state, in various fields across our state. I'm here to support these bills. My full testimony has been submitted to the committee, so I'm going to make a couple of other notes. I specifically am in support of helping reduce suicide rates. Suicide rates for males are highest among men over 75. This directly affects my patient population. A couple of months ago, I had a patient. He's stricken with diabetes. He's frustrated with complications of his illness. He has lost toes. He can't participate in the things that he used to care for. He mentions to me, I have a gun at home. Before I came into the hospital, I was going to use it. I spoke with his family and told them what he told me, and they removed the gun from their home. I'm thankful that I was in that opportunity where we could intervene. This was a pivotal point where we prevented a suicide attempt. That is why I support this bill. Family members are there. They hear things, and we need to support family members when we can. I also would like to mention that we frequently on my unit, because we have heart monitors, we frequently deal with mental health holds and the 72-hour holds, and these suicide holds are very stringent, and yes, our mental health system is strapped. So we need to support this issue from multiple angles. Thank you very much.
All right, thank you.
Senator Prozansky and members of the committee, my name is Charlie McKenna. I live in Eugene in Senator Prozansky's district. I'm the local lead for Mommies Demand Action for Gun Sense in America in Eugene, even though I'm not a mother. I worked with you and the governor in 2015 to pass the comprehensive background check law. That law, how we know, has saved lives in Oregon. Senate Bill 797, which I'm testifying in support of today, will enhance that law and make it an even better law and save even more Oregonians' lives. We have a gun epidemic in our nation, in our state. and we need to do things to keep the guns out of the hands of people who shouldn't have guns. There is almost universal agreement amongst Oregonians, hundreds of whom I talk to every month in my capacity with moms, that all agree guns should not be in the hands of dangerous people. This law, this bill, if it becomes law, will help strengthen our already existing laws to keep that from happening. It will also protect the most vulnerable members of our community, women who are subject to domestic abuse, who've been stalked. It will also allow local law enforcement a much better opportunity to apprehend those who have committed a crime by trying to buy a gun, even though they're legally prohibited from having a gun. Thank you very much. I'll submit a written testimony to you.
Thank you.